Hello, everyone. I'm just going to give us a moment here for everyone, all our attendees to get in. It takes a little moment to make sure that everyone's connected. So we'll just give a moment here for that. All right. So it looks like it's slowing down a little bit. So thank you, everyone, for coming to our online charter series on mobility rights and the COVID-19 travel restrictions. We really appreciate you joining us today. My name is Alina Rietsma. I'm the Public Legal Education Coordinator with the Center for Constitutional Studies at the University of Alberta in Edmonton. With us, of course, we have the lawyers you came to hear, Mr. Arthur M. Grant and Ms. Cara Zwibel. So usually at all events on the University of Alberta campus, we would acknowledge the territory that we're on. With this being a webinar, many of you are spread out, not just all over Canada, but also the world. So I'd really encourage you to reflect upon the land at your respective location and to think on those who came before you, who called and continue to call that land home. As I respectfully acknowledge that the center is located on Treaty 6 territory, a traditional gathering place for diverse Indigenous peoples, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Saulteaux, Inuit, and many others whose histories, languages, and cultures continue to influence our vibrant community today. So for the webinar today, the attendees will notice that the chat function has been disabled, but you can still ask questions. So if you'd like to ask questions, please use the Q&A button that you'll see at the bottom of your screen. You can hit that and then type in a question for the speakers. Each speaker is going to speak for about 15 to 20 minutes, so there should be some time to answer questions. And once the presentations are complete, we're going to try to get through as many questions as possible. Please note that there's also going to be a sort of short feedback form or summary at the end of the webinar. You'll have a pop-up with a link. Please do fill that out if you have time. We certainly appreciate tremendously. It's extremely invaluable to us, helps us to know things that we can improve on, ideas for future webinars. And lastly, please note that this webinar is being recorded, and we will have a recording available on the website in the next few days after the webinar. So before we get to the presentations, I would like to provide a brief introduction to both of our speakers who generously agreed to join us today and share their knowledge and time with us. We're quite lucky to have them with us here today. Arthur M. Grant is a partner at Grant Kovacs Norell, a law firm in BC, which was formed in 1997. He was called to the bar in BC in 1985 and has been a member of the Yukon Bar since 1992 and practices in civil litigation. He's been involved in a wide variety of cases, including Aboriginal and constitutional law, and he's appeared in all levels of court, including the Supreme Court. And was previously a law clerk for judges at the Supreme Court and a sessional law professor at the University of Ottawa. He's had a special interest in mobility rights, which we'll be talking about today, and he's going to provide us with a wonderful sort of big picture perspective on Section 6 mobility rights and some of the restrictions that we've seen in Canada during COVID. We also have with us Ms. Cara Zwibel, who's the Acting General Counsel of the Canadian Civil Liberties Association and the Director of the Fundamental Freedoms Program there. Prior to joining the Canadian Civil Liberties Association in 2010, she practiced commercial law, public law, and health law, and she received a Master of Laws degree from New York University as an Arthur T. Vanderbilt Scholar. The CCLA, or the Canadian Civil Liberties Association, was one of the applicants in recent litigation in Newfoundland and Labrador around mobility rights. And so she'll be able to provide us with a really detailed sort of insider view about that case, which actually had the decision released, I believe, about 10 days ago. So with that, I'm not going to take up any more time. We're going to have Mr. Grant present on general Section 6 mobility rights. So I'll turn it over to you.
Turned over?
Yes, you're turned over.
All right, let's see if I can go to this. There we go. Does that appear on the screen, Alina?
I haven't seen it. Did you hit share at the bottom?
I did. Let's go back again. Now seeing it?
Yes, you're perfect. There you go.
All right.
Perfect.
Great. So first of all, I'd like to thank the Center very much for the invitation to speak at this, and I'd also like to acknowledge that I am speaking from the unceded territories of the Coast Salish, Vancouver. I'm going to be talking about a subject matter that's been part of my legal existence since from even before I became a lawyer. Actually, I had my fingers into this mobility rights, and it's the mobility rights during the COVID-19 pandemic is the subject. And I've got my subtitle, The Often Overlooked Rights of Human Mobility. And I call them often overlooked because they've become sort of the poor cousins of some of the other charter protections like fundamental freedoms and Section 7's right to life, liberty, and security of the person, or to equality rights. Though some people may argue that the equality rights have not been given its full effect. So I'm going to be talking about this element. And so part of it is I'm going to be going through some of the interests that are involved in human mobility and why they're important and why historically they're important. So we've used human mobility. We use it every day of our existence pretty much. And unless very few of us don't use our human mobility. And we've done this on collective and individual bases for millennia. We do it today for all sorts of things. I did it this morning on my bicycle to get to work. We'll pick up our food. We go, we recreate. We visit friends and family. And doing so, we traverse very often political and territorial boundaries. For instance, this morning in coming to work, I traversed three municipalities, and so that's just something that we do as a general thing. We don't even think about it in most Western liberal democracies. We've used it over, as I say, for millennia. We've done it to move to new villages and towns and cities, to new countries. We've done it to found new countries and even new civilizations. And we've done it for good and bad purposes. We've traversed seas and oceans, continents, and there's been, throughout human existence, there's been diasporas from old countries to new countries and back again, often for the purposes of seeking better standards of living, but often to escape persecution or to unite with others of similar backgrounds. There's a whole bunch of reasons why there's been movement. I got up here two little pictures, one of U-Haul, which is what my son is doing today. He's moving himself. We also have movement for love. There's all sorts of reasons you move. And I ask you to think back over your own life and think over the life of your parents and your grandparents. And ask yourself, how often did they move for work, for education, for love, for trying to find a better place? Some came from overseas. And my grandparents came from the old country. One came from South Africa. Until I left home, my parents moved at least 8 times. I sort of counted up 8 times for work. And for myself, I can say I've lost count of the number of times I've moved for work or education. I'd venture it's around in excess of 20 times. And I've gone across the country for that purpose. And I continue to move throughout in terms of my existence. I can say, I'm happy to say my wife and I traveled at least once for love. So we often vote with our feet, and the capacity for humans to move has been a deeply rooted one, and one that I think we have to be careful to respect. Now I've got this picture here. These are of English yeomen, and I'll tell you why that's important. At least why that picture I've got up there. One of the earlier examples of the importance of mobility rights can be found in English history, and it's not just English history, of course, all sorts of histories, but I'm using this because there was a very early charter case called MIA versus Medical Services Commission of British Columbia, and Chief Justice McEachern did an in-depth review of the history of mobility rights. And at that time, British Columbia was trying to restrict mobility of doctors coming into British Columbia. The belief in the mid-80s was that there was too many doctors in British Columbia, believe it or not. And so the British Columbia Medical Services Commission was doing one of its very early attempts at what they called physician supply management. And they tried to restrict mobility of doctors within coming into British Columbia and then where they could work in British Columbia. So he started reviewing some of the history of the mobility rights. And he noted that at the time of conquest in 1066 in England, there were 4 classes in Anglo-Saxon society. There's the noble, the freeman, and the partially free man or serf, and lastly the slave or thrall. And the freeman, which later morphed into the yeoman, stood midway between the feudal aristocracy and the serfs. And he quoted, I'm going to read a little bit here. So the freemen held their land from the lord of the manor, but they generally gave him rent instead of servile labor. They might have 3 or 4 times as much land as an ordinary serf, and sometimes they hired laborers to assist them. Unlike the serfs, they could move to another manor if they saw fit, and without the lord's permission, could marry their daughters outside the manor or send their sons to study for the clergy. And then later on, this is a quote from the Hull and Albion's history of England and the British Empire. And then later on, he quoted Ridley on the history of England, saying freeholders were free to leave as they wished and to try to make a better bargain for other land with other lords. So the early yeomen, not only they were able to, or freemen, they were able to move about and vote with their feet. Not only did they have to pay rent, but they also had to provide military service to their noble, and they were known for their ability with the English longbow. That's the significance of this picture here, which became a very potent weapon against the French in the centuries after the conquest. So this notion of voting with your feet, which is long before freedom of religion, long before freedom of speech came to be accepted as fundamental rights, this was one of the fundamental rights that came to be passed not just to the freemen, but to all of English society. So this is being found to be found expression in our charter, and I'm taking you to section 6 of the charter, and I've got actually I should have highlighted 2 parts here. Section 6.1 is the part that gives rights of Canadian citizens. And they're the right to there's 3 rights that Section 6.1 has. There's the right to enter Canada, there's the right to remain in Canada, and the right to leave Canada. So there's 3 rights contained in Section 6.1. And I just have a couple of comments on Section 6.2. So actually, I'll just stop before I go there. Section 6.1, please note, if you go to the French version here, and you'll see that they reverse the order here. So right to enter and the right to remain are switched around. And tout citoyen canadien a le droit de demeurer au Canada. And then d'y entrer et d'en sortir. And I'll note that the French verb demeurer means first, it's a right to stay, it's a right to inhabit. It's a right to also be in. And so it can translate as the right to remain, but it's actually broader than the English verb to remain. It implies a sort of inhabitation. Section 6.2 also has differences in the French and English version. So we'll take a look at Section 6.2. Every citizen of Canada and every person who has the status of permanent resident of Canada has the right. These are permanent residents and Canadian citizens, not for everybody. Has the right, A, to move to and take up residence in any province, and B, to pursue the gaining of a livelihood in any province. Take a look at the French version for Section 6.2a. It gives a right to se déplacer dans tout le pays et d'établir leur résidence dans toute province. And so there's a big difference between the French and English version. The French version is much broader. The right to displace yourself or to move about the whole country is very different than the right to move to and take up residence in any province. And you'll see what's happened later on, I'll come back to this, that this has become a very restricted right. The right specified in subsection 2, and this gives our rights to allow provinces to impose laws of general application. So if you want to be a lawyer in British Columbia, you have to pass certain exams and pass certain standards. And that's okay for British Columbia to do that. But they can't discriminate primarily in the basis saying, and only people from British Columbia can apply. So this says that you cannot discriminate among persons primarily on the basis of province of present or previous residence. And then there's also a law providing for reasonable residency requirements for qualifications for receipt of publicly provided social services. And that's a, for instance, if you want to move, I found out the hard way that if you wanted to move to Quebec, I had to wait for 6 months to get become subject to the medical insurance program. Nothing like having to pay for your medical services up front before you receive them to make you appreciate the importance of medical insurance. So those are a couple other things I'd just like to make a note about Section 6. One is that they are for citizens or for citizens and permanent residents only. And secondly, it's one of the provisions in the Charter that is not subject to the notwithstanding clause, Section 33, and other provisions like the fundamental freedoms, like the legal rights, and like the equality rights. The province or the parliament can actually pass a law saying we're suspending or we're making this law apply notwithstanding any charter implications for those provisions. We can't do that with Section 6. Just one more provision that I'm putting in here, and that's the Section 1 limitations or justification clause. And this one here says the Canadian Charter of Rights guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by laws can be reasonably demonstrably justified in a free and democratic society. So reasonable limits prescribed by law, demonstrably justified, and approved in a free and democratic society. And that's the measure. We'll see this is a very important provision later on in terms of the pandemic. So Canadians can freely leave and stay in Canada, and initially during the pandemic, if you had COVID symptoms and you were Canadian, you were prohibited from entering Canada by air. So you could enter by land, by sea, by train, but not by air. This meant if you had COVID symptoms, the only country you could enter from would be the United States. You're pretty much any else in the world, your Section 6.1 right to enter Canada was suspended, unless you could somehow sail across the sea, and most of us can't do that. Now they've changed that restriction. So you can see here, this came from the federal government website. If you do not have symptoms and you're entering Canada, you're going to have to quarantine for 14 days. If you do have symptoms, you have to isolate for 14 days. I'm not quite certain about the difference. But they note that anyone who's traveling by commercial airlines may face the fact that the commercial airline may prevent you from boarding their aircraft. So practically speaking, there may be issues with your mobility rights to enter Canada, but it's not being imposed by the Canadian state per se. I should note in context of Section 6, international travel, that there was a lawsuit brought in Alberta against the federal government for its failure to issue passports to Canadians who want to travel internationally. And that was because of the shutdown. They simply didn't have any employees working on those passport applications. This, I followed up with the group pursuing this lawsuit and found out they've dropped it, because since then, the federal government sent its employees back to work, either remotely or otherwise, and so the lawsuit is really kind of moot. So I'd like to take a look at some provincial restrictions. So at the end of May, a fellow British Columbian, Caden Webb, gave up his dream of ever owning a piece of property here in Vancouver. The market was still crazy, and he was actually living in a camper van. So he discovered that with the help of his parents that he could buy 11 acres in PEI. And so he did. And he loaded up his van, took his dog, and had all his food for his trip across Canada, and started driving for his new home. He had proof of his title in PEI. When he got to the Quebec-New Brunswick border, he at first had to prove that he was moving to PEI, so he showed him his PEI property deed. He got the Confederation Bridge, drove across the bridge, and though he was able to show the PEI title deed, he couldn't show that he had sold anything in BC because he was living in a camper van. So he was told to go back. He said, "You can't come into PEI." He got to the other side of the Confederation Bridge, and he was told by the New Brunswick officers that if he didn't leave New Brunswick within 5 hours, they would arrest him and put his dog into a shelter. I tried to follow up, see what happened to this fellow. To my knowledge, he never sued either PEI or the New Brunswick governments, and I don't know if he ever made it to PEI. So this is probably the clearest example of a Section 6.2 right that I can find during the pandemic. This is the Kim Taylor case. In May, I won't take too much of Cara's thunder here, but this involved a woman by the name of Kim Taylor whose mother passed away in Newfoundland. She was originally from Newfoundland, but was living in Nova Scotia, and she wanted to go back and for the funeral, and she applied for an exemption, and it was refused. With the assistance of the Canadian Civil Liberties Association, she commenced a lawsuit against the Newfoundland government, and on September 17th, the Justice Barrage found that her Section 6 rights were violated, but that the violation was justified under Section 1. So I'll touch upon that briefly later on, but I'm not going to let Cara deal with that in more detail. After that happened, due to the relatively low incidence of COVID-19 in the Atlantic provinces, they banded together and created a travel bubble in which the residents of those provinces could circulate freely within the boundaries. As of last week, that bubble still persists, and other Canadians are being refused to enter the Atlantic provinces or have to apply for an exemption and being quarantined. Quebec, also early on in the pandemic, around April 1st, set up roadblocks into provincial bridges and restricted all non-essential travel. Essential trips included travel for essential work, medical appointments, or humanitarian purposes. The police were able to impose fines between $1,000 and $6,000 for non-compliance. Around mid-May, the borders reopened to non-essential travel, and since then, Quebec has remained open to other Canadians for purposes of travel. I'm not aware of any travel restrictions now in Quebec. I should also note that, to my knowledge, Ontario has not imposed any travel restrictions. Not only were there restrictions against interprovincial travel, but there have also been and remain restrictions against intra-provincial travel. For instance, in Manitoba, in May, the public health officer issued an order prohibiting travel to northern Manitoba and remote communities. This ban was lifted in June, and then in early September, I think September 8th, it was put back in place. So this sort of order is being used in other provinces. I believe it's being used in Saskatchewan. The territories were particularly vigilant in imposing and enforcing bans against non-essential travel over their borders, and all three territories issued public health orders that effectively banned non-essential travel starting in late May or March. The three territories then created a northern travel bubble, and that allowed movement across the north, including, interestingly, at least later on, Churchill, Manitoba. That's being a recent addition. When Yukon opened its border with British Columbia, it was expelled from the bubble by Nunavut and Northwest Territories. And so what I have here is a screenshot from the Nunavut government website. And you can see that it includes the residents of Northwest Territories and also Churchill, Manitoba can travel within this common travel area. Yukon has created its own unilateral travel bubble. It still allows the residents of Northwest Territories and Nunavut to enter, as long as they've been, that they can prove that they've been there and they've been there for 14 days. And they also have allowed British Columbia. And so if it's one thing about coming in, might be another problem for Northwest Territory residents, say, to go back.
So Mr. Grant, you have a couple minutes left.
Thank you. Okay. Indigenous governments have also acted to limit or prohibit travel into the territories. And while I'm not suggesting they're subject to the Charter, just note that they have both the Haida, the Halstuk Nation, and more recently a nation near and dear to my heart, the Tla'amin Nation near Paul River, which is where I have a home. They've had an outbreak in early September. They've put travel restrictions on their members and those trying to enter their territory. As I mentioned earlier on, the Section 6 actually was a Section 6.2 with its right to work, pursue the gaining of a livelihood in any province. That was a flashpoint for a lot of charter litigation. And so the first ever charter decision was from the Supreme Court of Canada was Skupinker versus Law Society of Upper Canada. And Skupinker had fulfilled, he was a South African resident, fulfilled or citizen, fulfilled all the requirements for membership bar, except he wasn't a Canadian citizen. And he challenged the constitutionality of that requirement. And this is under Section 6, not Section 15. And Justice Esty said that Section 6.2 did not give a freestanding right to work, divorced from the mobility rights. Then we came to another case called Black versus Law Society of Alberta, and again, involving lawyers, in this case, interprovincial law firms. And that was probably the high water mark of Section 6.2 cases. And what Justice Laforêt wrote for the majority there, saying that the Section 6.2 was intended to protect the right of the citizen to move about the country and to reside where he or she wishes to pursue his livelihood without regard to provincial boundaries. That's the broadest statement of Section 6.2 of the Supreme Court of Canada. And then we have a case called Canadian Egg Marketing Agency versus Richardson, also known as the Pineview Poultry decision. And this is what I say, bad facts make bad law. And here, this is dealt with really with mobility of eggs, unfortunately. And Richardson was the only egg producer for the Northwest Territories. And there was an egg marketing scheme which gave quotas to all the provinces, but none to the Northwest Territories. And while in this case, the decision spoke about the broad, important purposes of Section 6.2, they read it down with Section 6.3a, which was the discrimination, allowed you to discriminate on the basis of law's general application. And they found that this was really an interprovincial right to pursue a livelihood. And they focus on the interprovinciality of the mobility right rather than the mobility aspects of it. So having done that, we've had some interesting jurisprudential twists. And I mentioned Godbout versus Longueuil, which I think Cara will touch upon in more detail, so I won't deal with that. But what's happened is parties have gone to Section 7 to try to find the protection of the right to choose where one may reside or where one may move, as opposed to Section 6. And that has resulted, I think, in a distortion of the Charter, because Section 7, I don't think, was ever intended to have these sort of broad aspects. In this case, Godbout was required by the city of Longueuil to reside in the city of Longueuil if she wanted a job with the city of Longueuil, and she moved outside the city of Longueuil and was fired. And so 3 out of the 9 judges, with Justice Laforêt penning the judgment, said that actually your right to choose where you live is protected under Section 7. This has been a case, I think, where we find that because Section 6 wasn't given its value, we've got a, I think, undue focus on Section 7. Again, won't go too much into the Taylor decision, but I just want to note that there was an interesting analysis that points I'd like to make. First, he found that Section 6.2 wasn't violated. There was no real analysis of the difference between the French and English versions of Section 6.2. The right to se déplacer dans tout le pays was not even mentioned. it's largely ignored, I think, because of the Richardson-Pineview jurisprudence, found that Section 7 was not engaged, but this is the more important part. Section 6.1, the right to remain in Canada, was engaged. And he said that includes the right to not just remain in Canada, but remain through all of Canada. And it's not just one part. You can go anywhere in Canada. So this is I think the first, and it's a heartwarming reinvigoration of Section 6, the mobility human rights interest. Unfortunately for Ms. Taylor, he found that her mobility right had to give way to the common good. So I was told I couldn't poll, so I'm going to ask you to pose some questions. I'm almost done here, I think. Ask yourself, do you think it was reasonable and justified for the federal government to initially stop Canadians from entering Canada by air if they had COVID symptoms? And just sort of put that in mind and say, what do you think is reasonable? Do you think it's reasonable and justifiable for provinces and territories, such as Newfoundland, such as the other provinces I've said, to prevent Canadians or permanent residents from traveling to their province or territory during this time of pandemic? And then the last one, I'm going to ask the question, which is a twist here. Do you think it will be reasonable for the territories and provinces to limit the ability of Canadians and permanent residents from other provinces to work in their province or territory until they deem that they have sufficiently rebuilt their economies following the COVID pandemic? And the reason why I say that is this one's very near and dear to my heart. After MIA, which I was Chief Justice McEachran's decision, there was a bunch of other cases. And I was in one of the last successful Section 6.2 cases, was the case I took to the BC Court of Appeal. And it was about the BC government and the British Columbia Medical Association, as then was called, trying to limit the number of doctors coming from out of the province into British Columbia. There was a cap on how much money that they'd spend on medical services, and the BC doctors wanted them all that money for themselves. I also being involved in the Trans Mountain Pipeline case, and part of the factual background of that case, and sorry, I know many Alberta residents listen to this, was Alberta passing a turn off the tap bill in response to British Columbia's proposed regulations to regulate the amount of diluted bitumen that could be transported over BC's territories. I'm not saying that's good, bad, or otherwise. I'm just saying provinces do not always act altruistically. They often act so as to promote and protect their own. And this is to the expense of others who aren't part of their own. So we will have, quite possibly, provinces that are or believe themselves to be disadvantaged following this COVID pandemic. And we will have to be vigilant to see whether there are artificial barriers that are being erected along provincial borders out of pure economic self-interest. So watch the Taylor case as it goes through appeal. And especially as the second and third, God forbid, the third wave of COVID rolls through, watch cases like those of Caden Webb. I know that there must be justified limits to these mobility rights. They're not absolute, but we have to be careful as to what happens with these restrictions as we move from the pandemic to recovering from the economic effects of the crisis. Thank you very much.
Thank you so much, Mr. Grant. That was, I think, a really good foundation, and I think you asked some really thoughtful questions. So we'll now turn over to Ms. Zwibel.
Great, okay, hi. So first of all, thank you to the Center for this invitation. I'm very happy to talk about this topic and talk a little bit about the Taylor case in particular. I want to just say, so I don't get credit where it's not due, that I am not currently the acting general counsel. I held that position at the CCLA for a brief period when we were between general counsels, but I am, I direct our fundamental freedoms program. So I primarily do work around the fundamental freedoms in the Charter, Section 2. We haven't had a lot of mobility cases, and as Art mentioned, it's a less frequently litigated right. But this case and a decision to sort of delve into this area of mobility rights a bit came out of the fact that we were hearing from people who were being detrimentally affected by the restrictions on primarily on interprovincial travel. We certainly heard also from people, at least in the early days, who were separated from family by the US-Canada border, and we're trying to reunite, and we're facing really challenging circumstances with that. But we did hear from many people about the interprovincial travel restrictions, and one of the unique things with Newfoundland is that some provinces and territories, and Art talked about the territories having these restrictions in place. They put travel restrictions in place basically at the outset. So, in March, when declarations of states of emergency were made. And some of the Atlantic provinces did that as well. Newfoundland didn't do that. It had a requirement that people coming in from outside of the province self-isolate for a period of 14 days, which I should say I think is still a restriction on the mobility right, but a lesser restriction than one that says you can't come in to the province at all. So Newfoundland had that rule in place, and then in early May decided to ramp things up and essentially close the border to travel from other provinces with certain exceptions. So there were exceptions made for essential workers. There were exceptions made for residents. So residents could leave the province and return, but other Canadians couldn't necessarily enter. They also set up an exemption process where you could apply. And I mean, all of this is, I know we talk a lot about these being unprecedented and strange times, but this is a very strange situation that we find ourselves in Canada, where we're talking about the provincial border and who's being stopped at these borders, because we don't usually think, we think about the borders in terms of, maybe the trade of goods, but we typically don't think of them as real borders when it comes to the movement of people. And so we typically expect that I don't have to say why I want to go to BC or why I want to go to Newfoundland. I can go there. So accepting that this is an exceptional time, we still did want to, figure out where the boundaries lie. And we were concerned in particular because the decision to go from a less restrictive form of infringing on the mobility right, the requirement that individuals coming into the province self-isolate, and the decision to ramp it up to a more restrictive measure did not seem to be based on any evidence that we could find. And the government, in my view, didn't do a good job of sort of explaining why it was that this measure had to be taken. And if you look at the judgment that was rendered, I think you'll see. I mean, there's some discussion about the evidence and some of the modeling that was done, and during the actual hearing, so in Newfoundland, the process is a bit different than it is here in Ontario, where I am. But we had an application that involved affidavits, and there were affidavits that the government filed, and in Ontario, the cross-examinations on affidavits would take place out of court. In Newfoundland, they happened in the court. I apologize, I'm not sure why my camera is focusing and refocusing, but I'm not sure how to fix it right now. So the issue, when one of the physicians that testified was cross-examined, he had prepared some modeling data to talk about what would have happened if the travel restriction hadn't been put in place. And all of that evidence and modeling was done well after the travel restriction was put in place. So it wasn't done to sort of determine what the best measure was. It was done, in our view, in part to deal with the litigation. And it certainly played well, I think, on the media. The media got a lot of, there was a lot of interest, and there were headlines about how much larger, that infections would have likely soared without a travel restriction. But that was based on this modeling, which, there's certainly a lot of scientific interest and consensus around modeling being one way to try and determine what measures will work and what won't. But modeling is a scientific version of speculation. And so we were, I think, looking for, for evidence from the government about why that particular decision was made. And from the looks of it, it had a lot to do with sort of rumors and concerns about people not self-isolating. So there was a lot of angst about the possibility that people would be traveling into the province and not taking the self-isolation requirements seriously. Instead of, I think, thinking that maybe people would choose not to travel into the province because there was a self-isolation requirement. Newfoundland gets about 500,000 visitors each year, and and so the models sort of dealt with different versions of, how many less would we expect to come. And again, I think some of that, in my view, probably didn't take into account enough the situation we're in right now, where people are not really necessarily moving around a whole lot. And then we were looking at this. The other thing that Newfoundland did that was a little bit unique and different and concerning from our perspective was that in addition to passing this travel restriction, they amended their public health legislation to say that police have the right to detain and remove people to points of entry into the province. And they also increased the rights of inspectors under the Public Health Act to do searches. And they said these powers were necessary to deal with the new travel restrictions that were put in place. And that, caused us quite a bit of concern, the increase in police powers, the idea that you could be removed from the province on basically suspicion of violation of a public health order without certainly no due process that was baked into the legislation. And actually the way the legislation was worded, it applied to anyone. So residents of Newfoundland could be detained and taken to a point of entry and asked to leave the province. So those two factors made this, I think, something that got our attention. And then we were in touch with Ms. Taylor, who is from Newfoundland, as Art said, and had her mother pass away suddenly, I think the day of or the day before the travel restriction came into effect. And she took the steps that she was required to take. She sought an exemption. She had a self-isolation plan. She made arrangements for her mother's body to be stored by the funeral home until she could finish her self-isolation and have a service with her family members. And she was denied the exemption. Now, she was probably one of the first people to apply for an exemption, and it's quite possible that, had she applied a few days later when things were a little more settled in terms of how the province was dealing with these things, the answer would have been different. She did ask for reconsideration, and that reconsideration was eventually granted. Unfortunately for her, by that point, it was really too late. Her family had to make arrangements to deal with the passing of her mother. So that situation was one where we felt that she had been treated very poorly by the province. Her rights had been violated. There were others that were likely in the same situation. In fact, at the same time, there was another woman who was having a similar, who was in a similar circumstance, and both her and Ms. Taylor, their requests for reconsideration were granted and after the media got wind of the story. So, we were concerned about all of this, and so we took the case to court, and really it was an exercise in trying to get the government to put forward their basis for making this decision. So I know one of the questions someone has posed in the Q&A box has to do with, is mobility rights, are these rights absolute, and don't we have to make sacrifices because of what's going on? And I think the answer is absolutely not. The rights are not absolute, and absolutely, yes, we do need to make sacrifices. The question is how far do we go, and how far do we allow governments to go in restricting rights and what kind of evidence do they need to have to restrict those rights. So in Newfoundland, in our view, the evidence was that the self-isolation requirements were working well. When the government decided to put this travel restriction in place, they had flattened their curve. There was not a lot of virus circulating in the province. They say in part that's why it was important to do that then. But again, there wasn't any evidence that the self-isolation requirement wasn't working or wasn't going to work. There was this fear and distrust about people, breaking the self-isolation requirements. And there wasn't really a lot of concrete evidence in our view. Obviously, the judge has disagreed with that assessment, and we are considering the options in terms of an appeal. But this case was in part about, first of all, the scope of mobility rights, which I'll talk about a little bit more, and also that very important question of, what is the burden and onus on the government when they are restricting rights, even during exceptional circumstances. Do we let it become a situation where, fear that people won't follow the rules is enough to restrict rights? On the scope of mobility rights, we did make an argument based on both Section 6 and Section 7 because of a concern that Art highlighted, which is that Section 6 has been narrowly interpreted in some cases as an economic right. And so we put in a number of different arguments, but the one that the judge accepted was that Section 6.1, the right to remain in Canada, is the one that basically has this freestanding right to travel, and declined to sort of deal with it under Section 6.2, finding that that was about taking up residence or earning a livelihood. And Ms. Taylor wasn't seeking to do any of those things. And there were largely exemptions to deal with people who were planning to move to the province or going to work in the province. So I think it's an interesting decision to say that right to remain is a right to move freely within the country. And we put forward some arguments around the idea of mobility rights in international law, and the idea of what it means to be a part of a country, what it means to be a citizen of a country. That typically what it means is that you can be in that country, anywhere in that country, without having to seek permission or to seek a special exemption. So that's the decision that we got, that the right to remain in Canada was violated here, but that the restriction was reasonable. I know I haven't used all of my time, but I think I'll maybe stop so that there's time for questions.
Well, thank you so much for that, Ms. Zwibel. I'm just going to change the view here. There we go. Oh, and there we go. We have Mr. Grant back as well. So thank you so much, Ms. Zwibel, for that. And I know you sort of answered one of the questions already. So thank you both to our speakers. If both our speakers are okay with it, if we need to, we may go a little bit over time. I know we do have a little bit of time, but I don't know if we'll get all the questions. For attendees, if you do have questions, please submit them on the question answer button. You'll see a little Q&A button at the bottom of your screen, and we'll read out the questions and answer those. Now, Ms. Zwibel, you had sort of already answered the question of, is the right to move an absolute right, and discuss that a little bit. Mr. Grant, I don't know if you wanted to add anything to what Ms. Zwibel said about that?
Well, sure. All the rights in the Charter of Rights are not, they're all subject to reasonable limitation. There is, and the courts have made that clear, and that's includes Section 6. So it's not an absolute right. It can't be an absolute right. But again, the whole thing about you must be able to demonstrably justify why you're going to put a limit on that right. You've got to make sure you do it by way of a law. And you got to say it's reasonable, be reasonable in this free and democratic society as well as others. I think that's sort of the test we have to look at. And that requires some proof and some evidence. And so I know Cara was sort of alluding to the amount of evidence that they went through in that case, in the Taylor case. And you can get a copy of the judgment. It's, I think, 800 paragraphs long, Cara. It's a very long judgment, and the judge reviewed a lot of the evidence.
Thank you so much for that, Mr. Grant. I see there's a question on the issue of evidentiary standards. The question is, on the issue of evidentiary standards, are governments entitled to use a sort of precautionary principle approach given the emergent scientific understanding of COVID-19? And might that suggest that the standard will be more stringent as we learn more? So did either of you wish to talk to that?
I wouldn't mind trying to answer that a little, because this issue has come up, and we talked about the precautionary principle during the Taylor hearing. There were experts that were talking about that. So the precautionary principle in public health is this idea that you don't have to wait until you have absolute proof, that something is going to happen to take a measure to prevent it. And the commission that looked, the commission of inquiry that looked into the SARS crisis in Ontario many years ago talked about the importance of the precautionary principle, that we don't have to sort of wait until we know exactly what's going to happen. And so I think that's important, and it does play a role, but I think it plays, I think its role shouldn't be overstated. And I also think that what it means is that, I do think that as we learn more, we're going to have to expect and hold governments to a higher standard and a higher evidentiary burden. I also think it means that what is reasonable and justified at one moment in time may not be reasonable and justified at another point in time, because the idea behind some of these restrictions, the Atlantic bubble, for example, the idea and goal is that there may be an ability in some islands, if you engage in very strict policing of your borders, some islands arguably could eliminate COVID-19 from their territories. The issue here is that in this case, the island Newfoundland is part of the country in Canada. And we're not going to eliminate the virus, and the world is not going to eliminate the virus. So how long do we allow these restrictions to be in place, particularly when we don't, they're not put in place with a goal, with an end goal. There's no metric, and nothing has been stated about how do we know when this measure is no longer required. And so I think the precautionary principle should play an important role, but I worry that what governments are doing now, in many cases, not just related to travel, but related to all kinds of restrictions on our rights and liberties, is saying better safe than sorry, right? We want to do everything we can, and we better be safe than sorry. And I think that's a way that individuals can choose to live, but I don't think it's a way that a democracy that has a charter that that protects fundamental rights can operate. It can't just be a better safe than sorry, because that leads to a police state. I mean, I don't like to sound like an alarmist, but I do really worry about giving so much deference to the government.
Mr. Grant, did you want to comment on that at all?
Sure, I won't repeat what Cara has said so well, and I will say this. I think the first, a couple comments. First, I think that the precautionary principle was very motivating for Justice Barrage in the Taylor decision, based on my review of the reasons. I don't know whether Cara shares that or not, but I think that was definitely something that was motivating to Justice Barrage, and he, in as much, said so, I think, in the judgment. The other thing I was going to say is this, we have to put this in context, and Cara alluded to this. We're a federation, we're a country. And it's one thing for a country, and you take New Zealand as an example, to shut down its borders and say no one's allowed in, and we're going to deal with this, and once we've eradicated it, we're going to keep it that way. And even for New Zealand, that's not being 100% successful. But that's a decision, national decision that can be made. I don't know if that can be done in a federation and federation country. I think there's some limits that need to be imposed on that.
Thank you so much for that. Just taking a quick look through the questions here. So there's a question, did the court in Taylor say that the right to travel within Canada was solely the right of citizens under Section 6.1 and that permanent residents only had under Section 6.2 the right to travel to move to another province or to work, but not a general right to travel within Canada?
I mean, the court didn't explicitly, the court grounded the right to move freely in Section 6.1, and Section 6.1 talks about Canadian citizens. I would argue that that the Constitution, the Charter, is a floor and not a ceiling, and so there could be arguments made to say that this is a right that people in Canada have. But I can certainly see the argument being made that as a matter of statutory interpretation and based on the grounding that the judge found there, that is the exclusive sort of right of citizens and not of permanent residents. I don't know what you make of that, Art.
Well, I don't think the court said that, but as this is a question from an old friend of mine. Bonjour, Yves. I do believe this to be the situation architecturally. Section 6.1 is a right conferred only on Canadian citizens. It's not conferred on permanent residents. So therefore, given that that's where he found the right to move across provincial borders, not for the purpose of moving, take out residents, not for the purpose of pursuing work, just to move, that's something that only Canadian citizens would have based on logically based on the Justice Barrage's interpretation. I still think that we need to take a look at Section 6.2a and the French version of that and give that some life, because it stands. Actually, if you read the French version of the Richardson decision, the Pineview Poultry decision, when they quote the judgment, it actually sometimes doesn't make sense, because they actually use the French words from the Charter, but then say it's only interprovincial. It's not a right to move anywhere within the country.
Thank you so much. So we have another comment that's thanking both our speakers today. The comment and then a question with it is, I found it interesting that the judge decided this case on the basis of the right to remain under Section 6.1 as opposed to the right to enter, as the issue here was the right to enter a particular province. Does the right to enter in 6.1 only apply to individuals crossing international borders into Canada and not to crossing provincial lines?
Yes.
I've jumped the line a few times. So.
Yes, I think that's correct. I think that's correct in both versions of the Charter as well. I don't think he actually stated that, but I think that's the correct analysis.
Any comments, Ms. Zwibel?
No.
There's a question here. It says, any thoughts on doctrinal mobility, as some provinces may seek to allow only billing numbers in some areas of their own province? So an affected doctor could not practice in some areas.
That's the area I litigated for the better part of a decade. And so they tried doing that here in British Columbia. And I know that's been tried in the past. And I think they'd have to make sure that whatever limitations are put in place are going to, based on if it's a Canadian doctor, a Canadian citizen doctor, they're going to have to make sure that there's reasonable limitations. So in other words, a billing number that's, if you have a new doctor coming into practice, they're going to try, the provinces may want to try to say, we want you to practice in, say, Vanderhoof, British Columbia. It's a remote community in British Columbia. And so you have a billing number there. This will, again, I think, engage the whole arguments that Godbout raised about right to build, choose your homes, choose where you live. That's an important interest, important concept that needs to be protected under our constitutional system. And I can see that being a difficult one for them to create. They tried in the past. Case I litigated was Waldman versus Medical Services Commission, and I can see it happening again. So I don't think we're done with this issue. We may find a reinvigorated Section 6 analysis.
Thank you so much for that. Ms. Zwibel, did you want to add anything?
No, thank you.
So we're basically at time here. I hope our speakers are okay if we go with one more question. I don't want to impose too much. It says the court should take into account the level of risk the person requiring permission to enter the province represents, doesn't it? So I think they mean doesn't the court have to take that into consideration?
So I mean, I think that one of the arguments that we made in terms of the Section 1 analysis of the restriction on interprovincial travel had to do with you know, some of the arbitrariness in how this all operates, and also yeah, what measures could be taken. I mean, one thing is if you get to the level of saying, you know, you need to analyze the level of risk that each individual poses, then I think you do have to do a very kind of vigorous vetting of everyone coming into the province, and that's something that is probably not feasible or desirable. But you know, in Ms. Taylor's case, for example, we pointed out that Ms. Taylor has a sister who lives in Newfoundland, and we pointed out to the judge that if her sister had been visiting her at the time that her mother passed away, if Ms. Taylor's sister had been visiting Ms. Taylor in Halifax when her mother passed away, her sister could return to Newfoundland, would have to self-isolate for 14 days, but Ms. Taylor couldn't. And so there, I think you get to, I mean, partially it's an equality argument about, you know, a province of residence, it's a preference for residences, for residents, but there are certainly questions about whether all of these restrictions, you know, make sense when you view them all together. I've been hearing from people who are, you know, looking to have to move around, and now actually for many people the self-isolation requirement is becoming a real bar. So people who work in one province and reside in another, and every time they return to work, they're expected to self-isolate for 2 weeks, which means that if they have 3 weeks between work stints, they have to spend 2 of those 3 weeks in a province where they don't live, isolating by themselves. And the question is, you know, are there other things we could do to mitigate the risk that that person poses? I think at this point, maybe our testing is sufficient to maybe address that problem. But definitely there are a lot of factors that can go into this question of, you know, what is a reasonable restriction?
Thank you so much. Mr. Grant, did you want to comment at all?
No, I think Cara's answered that very well, and I think we have, it's going to be one of those things where as we know more about this disease, as we know more about the pandemic and how to handle it, the measures that are reasonable will change. And so what sort of degree of risk we'll understand better. We should be able to be a bit more fine-tuned with our responses, and the government should be reasonably nimble in changing that response, given that they're dealing with constitutional rights.
Thank you so much. So we are unfortunately past time. I did let us go a little bit past time because I thought both of our speakers had some very interesting things to say, and I wanted to at least get through some of the questions. So I'd like to thank again both Mr. Grant and Ms. Zwibel for being here and generously sharing with us all their knowledge and time with us, and for helping us to better understand mobility rights. I'd also like to thank Martin Gotthelf, our administrator, and Patricia Paradis, who's our executive director, for their assistance in organizing this event. And of course, I'd like to thank all our attendees who showed up today for joining us and for participating in this webinar. We really hope that you found it interesting and useful. And lastly, just a reminder that for the attendees, you'll be receiving a short feedback form. There'll be a link that'll pop up once this webinar is over, and we'd really appreciate if you take the time to fill that out because it's critical to our funding as well as our future programming. So thank you so much, everyone. Thank you so much, Ms. Zwibel, Mr. Grant, and thank you so much to our attendees for joining us today. Take care, everyone.
Thank you.